Today, we are talking about who pays sexual assault cases judgment. So let's get into this topic. I'm Natalie Gerry, the principal lawyer and founder of Gerry Law. I help injured people get the compensation they deserve for their injuries. So, when you win your sexual assault lawsuit, the court orders the person who assaulted you to pay you money, and this is called a judgment. However, winning the judgment is only one step because the next step is actually collecting that money, which can be difficult. If the court says that you're owed $500,000, for example, we have to collect that money from the person who assaulted you. This means we might have to sell their belongings, take money from their bank account, or take a portion of their paycheck. Or if they own property, then we may have to move to sell that property in order to pay the judgment. If the person doesn't have enough money or assets, though, it becomes very difficult to get the full amount that you are awarded. And in some cases, you might not get any money at all. So this is an issue that has to be assessed much before the lawsuit is pursued. And your lawyer will do searches to find out if the defendant owns property, or your lawyer will look into all avenues of vicarious liability. So for anyone who might be responsible for the assault who is associated with the perpetrator, for example, the person's employer, or if it's a priest who's doing the assaulting, then it could be the church who may have to pay. If it's a government employee who assaults someone, the government might be responsible for paying the judgment. So this is called vicarious liability and is a very important factor in your case, and one that your lawyer will assess closely to see if there is a party that has the financial resources to pay the judgment who could be responsible. If there's no employer or organization that can be held responsible, and the person who assaulted you doesn't have money or assets, which is what we call judgment proof, it might not be worth suing them because you won't be able to collect any money, even if you win the case. And this is really tough to hear, and it is a really hard aspect of sexual assault lawsuits in that it might not be worth pursuing a civil action if you won't collect money at the end of the day. You might also be wondering, though, if the person who assaulted you can declare bankruptcy to avoid paying you. The good news here is that they cannot. There is a specific rule in the law that says that bankruptcy does not erase debts from judgments for things like bodily harm or sexual assault. So this means that even if they declare bankruptcy, they won't escape the obligation to pay you. Overall, if you've experienced sexual assault, then you should contact a lawyer who can give you advice about what the best course of action is for you and who can get some clarity around whether or not the perpetrator has assets that could help to pay the judgment that you get at the end of the day if you're successful. I'm Natalie Gerry with Gerry Law. I'd be happy to speak with you about your specific circumstances, as this is just general legal information.